exit out of that browser, just that tab.
And hit that?
Yeah, just hit that once that, gets done. There you go.
Now I can hit that.
Yes,
Otherwise, I'm watching me.
correct. And you'll,
Now I go,
now go down to the Zoom thing on the bottom. There you go.
add full screen.
Yeah.
Where's
And
my,
then do
see waiting
participant?
room? Or do I see, yeah, just see waiting room?
Yeah, you can do that too. Or, here. Exit out of that.
Hit that?
And go down there.
Here?
Mhm.
Like over, it'd be like over there.
Do exit full screen.
Oh, there you go. So I got La Luzerne. It says 15 people are waiting. It says one participant in the meeting. That's me. So I should go to La Luzerne first to see what he's got, right? Or how do I look and see who everybody is?
Right here. You see this little thing?
Yeah. Oh, I got Brian Sears, Justin the clerk. So I gotta admit him. And then he's a co-host. Got Addison Sadiewater, Pincel, Hartman, Stavros, Bill Franks, and Melissa Walk. Okay. I should probably let all the attorneys in, right?
You can do that.
Who's Brian Sears? Oh, okay.
Can rename yourself.
Because I'm not in it.
Hello, everybody.
Judge,
Judge.
Getting you in, I had some trouble getting in, so that's why we're starting a little bit late. My technological skills aren't exactly up to par. So anyway, I got Mr. La Luzerne in here, Mr. Pincel, Mr. Franks, Mr. Hartman, Ms. Walk, and Mr. Sadiewater. I think that's all the attorneys I saw out in the,
Judge, Mr. Bertucci is in my office using my assistant's laptop. It may show up as Jessica Bonanno.
okay, I'll bring him in then too.
Yeah, he wasn't able to connect using his own computer, so he's using hers.
And just so everyone's aware, I also have a 7-Eleven here, Emin Dernovshek. So he's just sitting in and watching someone else here with me.
Ruby. So Mr. Bertucci's in, but I don't see him. So can you hear me, Mr. Bertucci?
Yes, sir.
Okay.
Video.
So who's got something ready to go?
Judge, I think Mr. Hartman had a couple cases. I've got about 10 cases disposed of, so I would defer to him if he's ready to go, Judge.
Judge, good morning. Both my cases are with Mr. Simonian, so unless he's here, I have nothing ready at this moment.
Mr. Simonian is not showing up yet. Oh, I do have. I am letting Mr. Stavros in now. I just saw his name up here.
Judge, Mr. Franks and I have a plea.
Oh, Mr. Stavros. Okay.
Mr. Stavros and I just have I think it's a motion for early termination that he's filed, so that should be rather quick.
Okay. What's the motion?
Judge, this is on 18 DT 61. It's Lake Bluff versus Daniel Bolger. And Mr. Stavros has represented the defendant. He was sentenced to 2 years of misdemeanor probation on reckless driving on June 18th of 2019. And I believe Mr. Stavros has a motion for early termination.
Looks like I'm looking at a report dated, well, it looks like it's a year ago. At that time, he had a balance of 0 owed. Looks like he completed his DUI school. He had Lake County jail sentence, which was stayed. So I guess that continues to be stayed. And he did all of his public service. So what's the village's position?
Well, Judge, like I said, yeah, normally I'd be opposed to early termination because that was the agreement, but under the current circumstances, he's in full compliance. We might as well take this case off the docket and term it.
Okay, then, have you already submitted a proposed order, Mr. Stavros? I don't hear you. Hold on. Looks like, can you hear me now, Mr. Stavros? Can you hear?
Yes, I can hear you. Can you hear me?
Okay. Now I do. Do you have a proposed order?
Judge, I did not submit a proposed order yet because he's paid probation service fees in Lake County up front. It was subsequently transferred to Cook County. He's paid all those up front. So I just wanted to make sure in that order I can include that the Lake County probation fees will be reimbursed or refunded.
Actually, in the order, the status report from June 15th, okay, so June 15th, 2020, it looks like it actually says that he was overpaid his supervision fees to Lake County and that he's due a 22-month refund. So it looks like, yeah, I would include that in the order, just to be clear.
So specify 22-month refund for probation.
That's what the report says, which is dated June 15th, 2020.
Okay. Order to follow.
Okey-doke.
Thank you, Judge.
Do you have anything else, Mr. Stavros?
That's it for today.
Okay, take care, sir.
Thank you. You too.
Judge, I've got 3 pleas with Mr. Lalazerne. So I've got
Okay.
1 guy in my office and 2 in your waiting room.
Okay. Okay, and then Ms. Wack and Mr. Franks, you've got one. Who's the client there?
Michael Williams, and he is in the waiting room.
Okay. So you've got one. Mr. Hartman, you've got how many?
Judge, I have 2 cases. One will be a plea. One is just up for arraignment.
You're waiting on Mr. Simonian on both?
Yes.
Okay. Nice echo. Well, why don't we try and knock out Mr. Franks and Ms. Watts, since they only have one.
Sounds good, Judge.
And your client is who?
Michael Williams.
Okay. I can't wait until July 10th when we have 100 actual people on the call. Should be a lot of fun. Okay. Mr. Williams, can you hear us?
I'm texting him right now.
Well, he's in, but he's muted right now. See if I can unmute him. Can you hear me, Mr. Williams?
Yes, sir. Can you hear me?
Yes, sir. Okay, sum and substance of the negotiation.
Mr. Franks, do you want me to recite it?
He's muted right now for the moment too. There you go.
Mr. Franks, do you want me to recite the plea? Do you see him? I can't see him anymore.
No, he's there, but he's,
Okay, yeah, he's muted though.
well, I keep hitting the,
Oh,
Hear me now?
okay, yeah, there we go.
he was muted on his end.
Okay, got it.
This is my first Zoom.
Mr. Franks, do you want me to recite the plea?
That'll be fine, Melissa.
Okay, Judge, Mr. Williams will be pleading guilty to 19 TR 66321 which the village is seeking leave to amend, and we do have an agreed order that we submitted to amend that charge up to a reckless driving. In
That's
exchange
correct.
for that, Judge, Mr. Williams would be placed on 12 months of court supervision and pay a $1,000 fine plus the statutory assessments. He would complete a live victim impact panel. He would obtain a NICASA evaluation within 45 days from today's date and follow all of those recommendations. 19 DT 1497 and 19 TR 66320 are being dismissed as part of the agreement, Judge. And that is the sum and substance of the negotiation.
That's correct, Your Honor. And I asked for leave to amend.
Okay. Mr. Williams, Mr. Williams, obviously you're not here in the courtroom. Nobody is other than myself and my clerk. You understand, and I have in front of me a signed document that says waiver of right to be physically present in criminal proceedings. It says, I, Michael R. Williams, defendant in the above entitled cause, acknowledge that I have been advised and understand that I have the constitutional right to be present at all proceedings regarding my cases. Further, that I have a constitutional right to confront my accusers. Finally, I have been advised that I have a right to a public proceeding, and that you, in fact, executed this, which says, I hereby knowingly and voluntarily agree to waive my physical presence in the courtroom and my right to a public proceeding, and I agree to participate in court proceeding via video teleconferencing. And obviously, this is all because of the state of emergency that's been declared by the governor of the state of Illinois in order to prevent the spread of the coronavirus. You understand all that?
Yes, sir.
And you agree to that? You signed that document?
Yes, sir.
Okay. Do we have any priors? Criminal record?
He does
No,
have,
sir.
and that was, I believe, 4 years ago, Judge, but the basis of the amendment is due to factual problems with the case.
What was 4 years ago?
A DUI.
What happened on that?
He got supervision.
Is he eligible for supervision then on this?
He's, because it's being amended to a reckless, he is eligible for court supervision.
Okay.
That's my understanding.
Okay, it's the court's understanding you wish to waive your right to both the jury trial and bench trial and plead guilty to the charge of reckless driving, a Class A misdemeanor, which has a potential penalty of a year in jail or a $2,500 fine. Is that so?
Yes, sir.
You understand you have the right to a trial, be a jury trial or bench trial. A jury trial is a trial where 12 people from the community would be picked, the community being Lake County, Illinois. They would hear the evidence and they would make a determination as to whether or not the state's proven its case beyond a reasonable doubt. Do you understand that?
Yes, sir.
Or a bench trial, that's where a judge would hear the evidence.
I just lost the audio, Your Honor.
Or you have the right to a bench trial, that's where a judge would hear the evidence and make that decision. Do you understand that?
Yes, sir.
Has anybody forced you, threatened you, made you any promises other than what the court has heard here today to get you to waive your right to both the jury trial and a bench trial?
No, sir.
You had sufficient time to discuss this with your attorney?
Yes, sir.
Satisfied with her representation?
Yes, sir.
Feel that this is in your best interest?
Yes, sir.
You're not under the influence of drugs or alcohol today?
No, I am not, sir.
You understand that by waiving your right to a trial, you're waiving your right to confront witnesses that may be called to testify against you, call your own witnesses, or even testify on your own behalf.
Yes, sir.
Court will find that there's a no voluntary waiver of the defendant's right to both the jury trial and a bench trial, factual basis.
Factual basis on the date and time in question. Mr. Williams, in the village of Kildare at a BP station, exited that station, crossed 3 lanes of traffic, and then went into a left-hand turn lane. When the light turned green, he delayed, and then when he proceeded, he took a wide turn into the other oncoming lane of traffic. And all this occurred with other pedestrians or other vehicles present.
So stipulated? Counsel, so stipulated? Court will find that there's a sufficient factual basis to support the plea. This is a final and appealable order, which means you have days to withdraw your plea. If you wish to do so, it has to be done so in writing. If it's granted, basically you start all over again, and the matter is set for trial, and all matters would be reinstated to their original charges. If denied, you'd have 30 days to appeal to the appellate court in Elgin, Illinois. If for either of those two procedures you wish to have an attorney and cannot afford one, one would be appointed to represent you free of charge if you're found to be indigent. Additionally, all records and transcripts of these proceedings would be provided free of charge upon that finding of indigency. Clerk's office would assist you in filing a notice of appeal. Do you understand that?
Yes, sir.
You are under the jurisdiction of the court while you're on supervision, which means if you fail to comply with the court-ordered conditions of supervision, the state can file a petition to revoke your supervision. If they prevail, you could be resentenced up to the maximum. If you fail to show up when it's set for a hearing, there could be a hearing held without you being present. If the state prevails, you could be resentenced up to the maximum without even being here. Do you understand that?
Yes, sir.
Now, you have to contact the compliance coordinator's office within 24 hours. Do you understand that?
Yes, sir.
Okay, anything from either side, other than what I've just heard?
No, Judge.
No, Judge.
That being the case, the court will concur with the negotiation and sentence the defendant as set forth in the order and is presented here today. Thanks, everybody.
Thank you, Judge. I do have one other matter with Mr. Lalazern, and that's just a continuance.
Thank you, Judge.
Take care, Mr.
And that is 19 DT 925 and 20 DT 241, Christopher Cray.
That's correct, Judge. I've got the file.
Okay. That's your pleasure.
Judge,
Is
if
your
we
client-
continue the matter, we have a plea worked out. I just have to have my client sign it and I have to explain everything to him. If we can continue the matter to July 24th for plea.
No objection, Judge.
What was the number on that one?
It was 19 DT
No, I
925.
don't mean that. I'm asking my clerk. I don't have it right in front of me. I had them pull the numbers as far as numbers of bodies for these upcoming July dates, and July 10th had over 100 bodies. I'm not talking cases, I'm talking people.
Okay.
July 24th was no picnic either, if I recall.
July 24th is 74 in the morning, but only 5 in the afternoon.
74 people right now on the morning call, which on a regular set of circumstances would be fine, but in a virtual waiting room might be a little crowded. But
Can we, Your Honor, allow us to go out to August? Does that make things?
we're gonna have to, because I'm gonna, until we get through with this, I'm gonna probably cap everything at 50. I'm gonna cap everything at 50 and then 50 people, that is, and then to try and get since I'm just coming into this call, try and get a handle on it, and then since we don't have jury trials for a while, Monday, Tuesdays, and Wednesdays are gonna be stacked with bench trials.
Okay, can we do the August 7th? Does that work?
Fine with us.
Let's go August 14th. I'm not sure if I'm here August 7th.
Okay,
Okay.
so I prosecute the second and third Friday of every month, so it would either have to be the 7th or the last Friday of August.
Let's go to 28th. How are you guys on how about if we went to July 24th in the afternoon?
That's fine, Judge.
How's that for you, Ms. Walk?
Yeah, that's great.
Okay, 24th in the afternoon.
Perfect.
Good.
Thank you, Judge. Have a great day. Thank you, Mr.
Take care.
Lalazern. Bye, everyone.
Bye now.
Thank you, Judge.
Judge, I just got an email from Mr. Simonian that he's trying to get in. I don't know what exactly that means, but.
And I know exactly what it means. Believe me. So, Mr. Lalazern, we've got Mr. Pincel, and we've got Mr. Bertucci. Let's knock those gentlemen out.
Judge, I've got a quick one with Mr. Bertucci. I've got one plea and then a continuance on a hearing from 10 o'clock. We can knock that out pretty quick.
Okay. Are those both with Mr. Bertucci?
Yes, Judge. Judge, let me,
You know, when Mr. Bertucci kicks on, this is when we get the echo. So I'm not sure what issue is in your other room.
I'm not sure. Maybe it's because we're in the same room, Judge?
maybe.
Anyway, 19 DT 1288, Highland Park versus Omar Ramirez. And that's going to be continued for hearing. But I'll ask Mr. Bertucci what date.
Judge, that's all correct. I'm just asking for a status date in July, just based on the idea that hearings aren't probably going to be run in person for a while. So if we could just on our motion have a status date, perhaps
Just
say.
so we get, okay, Mr. Bertucci and Mr. Lalazar and everybody else. The fact is, I don't know when we're gonna have live, hearings. So we're gonna be running Zoom hearings. I mean, I am not gonna let this call's with the couple month hiatus is backed up. I've already run a couple hearings, as have the other judges, so we're gonna be running hearings. And realistically, it seems it's been beneficial for defense attorneys to have their clients in their office because they have trouble getting on from home sometimes, or there's echoes, or there's dogs barking, or there's people walking around in the background bringing them bowls of Cheerios, and it helps, as Mr. Lalazern's done, have his police officer there in his office ready to testify. So, I mean, I'm not sure when we're going to be live. I'm hoping sooner than later because this is really a pain. But so if you need a new date, that's fine. But come next time, if it's virtual, it's virtual. We're going to run the hearing.
Judge, I would just say we're also working towards a potential.
It looks like I lost Mr. Bertucci.
Yeah, you're,
Okay, yeah, I mean, it just.
He's back.
I can't reconnect.
Well, I don't see his picture, but I see his name up there.
Oh, there it is, okay, I should be in now. Yeah.
But now you're muted. Now, there you are.
Yes, Judge, I would just point
Okay.
out that Mr. Laluzern and I have been in conversations about a potential resolution. I'm hoping that we can have it resolved in July.
So you think it can be resolved in July?
Yes, sir.
Are you good with an afternoon?
If need be, yes, sir.
How about the 24th at 1:30 for status and pretrial?
Yes, sir.
Work for you, Mr. Lalazern?
yes, Judge.
Okey-doke. What's the other one you have, Mr. Bertucci?
Judge, this is 19 DT 1579. Lake Forest versus Jim Calloway.
Let me get Mr. Calloway in here. Okay, Mr. Calloway. He's muted.
Is that better?
Can you hear me, Mr. Calloway?
Yes, sir. Can you hear me?
Yeah.
There we go.
Now I can see you. So what do we have, gentlemen?
Judge, I believe we have filed a motion asking leave to amend the charge from 11-501 to 11-503.
Okay.
We'd ask the court to grant that motion to amend. If the court does, so we have a plea to the amended charge.
As far as priors,
No priors, Judge. He's a first offender.
okay. Mr. Calloway, I have a document in front, excuse me, it appears that you signed, it's a waiver of right to be physically present during criminal proceedings. And it says, I, Jim Calloway, the defendant in the above entitled cause, acknowledge that I have been advised and understand that I have a constitutional right to be present at all proceedings regarding my case. Further, that I have a constitutional right to confront my accusers. Finally, I have been advised that I have a right to a public proceeding. And that you acknowledge and understand that a state of emergency has been declared by the governor of the state of Illinois in order to prevent the spread of the coronavirus, and in the interest of the health and safety of yourself, all court users, staff, and judicial officers during these extraordinary circumstances, that you've acknowledged that you, and you've executed this document that says you knowingly and voluntarily agree to waive your physical presence in the courtroom and your right to a public proceeding, and I agree to participate in a court proceeding via video teleconference. Is that so?
Yes, sir.
And just so you know, and I guess just for everybody's knowledge, it actually is a public proceeding, and that we're live on YouTube.
Okay.
Okay? So, seven substances of negotiation.
Your Honor, we would enter a plea of guilty to the amended charge of reckless driving. He would be placed on 12 months of court supervision with the usual terms and conditions. Judge, he has already completed the level 2 moderate DUI program. He is to complete a live victim impact panel. Judge, there is 19 TR 69009, which would be dismissed. That is our agreement.
That's correct, Judge.
Okay, sir, it's the court's understanding you wish to waive your right to both a jury trial and bench trial and plead guilty to the charge of reckless driving, a Class A misdemeanor, which has a potential penalty of a year in jail and or a $2,500 fine. Is that so?
Yes, sir.
You understand you have the right to both a jury trial and a bench trial, that a jury trial is a trial where 12 people from the community would be picked, the community being Lake County, Illinois. They would hear the evidence and they would make a determination as to whether or not the state's proven its case beyond a reasonable doubt. Do you understand that?
Yes, sir.
Or a bench trial, that's where a judge would hear the evidence and make that determination. Do you understand that?
Yes, sir.
Then they'd be forced you, threatened you, made you any promises other than what the court has heard here today to get you to waive your right to both a jury trial and a bench trial.
I'm sorry. I didn't...
Nobody's forced you or threatened you to get you to do that.
No, sir. No, sir. I didn't hear
You've had
this.
sufficient time to discuss this with your attorney?
I did discuss it with my attorney. Yes, sir.
Satisfied with his representation?
Yes, sir.
That this is in your best interest?
Yes, sir.
Not under the influence of drugs or alcohol today?
No, sir.
You understand that by waiving your right to trial, you're waiving your right to confront witnesses that may be called to testify against you, call your own witnesses, or even testify on your own behalf. Do you understand that?
Yes, sir.
Court will find that there's a knowing and voluntary waiver of the defendant's right to both the jury trial and a bench trial. Factual basis.
Judge, if the matter would come to trial, Officer Essman from the Lake Forest Police Department would testify that he clocked the defendant going over 80 miles an hour in a 35-mile-an-hour speed zone and otherwise was driving in a wanton manner, endangering the safety of persons and properties on the city streets of the city of Lake Forest.
Stipulated?
So stipulated for purposes of this plea, Judge.
Court will find that there's a sufficient factual basis for the plea. This is a final and appealable order, which means you have 30 days to withdraw your plea. If you wish to do so, it has to be done so in writing. If it's granted, basically start all over again. The matter would be reinstated with the original charges and set for trial. If denied, you'd have 30 days to appeal to the appellate court in Elgin, Illinois. If for either of those two procedures you wish to have an attorney, you cannot afford one, one would be appointed to represent you free of charge if you were found to be indigent. Additionally, all records and transcripts of these proceedings would be provided free of charge upon the finding of indigency, and the clerk's office would assist you in filing a notice of appeal. Do you understand that?
Yes, sir.
You are under the jurisdiction of the court while you're on supervision, which means if you fail to comply with the court-ordered conditions of supervision, the state could file a petition to revoke your supervision. If they prevailed, you could be resentenced up to the maximum. If you fail to show up when set for a hearing, there could be a hearing held without you being present. If the state prevailed, you could be resentenced without even being here. Do you understand that?
Yes, sir.
You need to contact the compliance coordinator's office within 24 hours. Do you understand that? And Mr. Bertucci can get you all that information.
Okay.
Okay. Anything else from either side?
Nothing in this case, Judge.
No, sir, Judge.
That being the case, the court will concur with the negotiation and sentence the defendant as presented here in court today. Good luck, sir.
Thank you.
Okay, you're done, Mr. Bertucci? Have a good day.
Yes, sir. Thank you, Judge.
Okay. Take care, Mr. Callaway. Good luck.
Thank you.
Okay, Mr. Pincel and Mr. Lalazerne, you ready?
Yes, Judge.
Yes, Judge.
Mr. Sadiewater, do you have anything, or are you just hanging around?
Judge, I have, there's a pro se motion up, Judge. I don't know if the guy's gonna show up. It's Crump 13 CF 3052, but I have no idea if the guy's actually gonna actually be here today. So
Jose?
Okay, well, we'll deal with that one when we,
right, so there's no rush on it.
okay.
Judge,
We
I've
have-
got a Jose Torres who's in my office. He should have all the paperwork. He does not need an interpreter. But if you want to do other, whatever you want.
Let's do it, sir.
All right, Mr. Torres is with me. You should be able to see him on your screen.
I do. Hello, Mr. Torres.
Hello.
Mr. Torres, I have got a document here, waiver of right to be physically present during criminal proceedings. You understand that you have, I've got a form, it looks like you signed it, as did Mr. Pincel, or he prepared it. You understand you have the constitutional right to be present at all proceedings regarding your case. Further, that you have a constitutional right to confront your accuser. Finally, you've been advised that you have a right to a public proceeding.
Yes.
And it says you acknowledge and understand that a state of emergency has been declared by the governor and in order to prevent the spread of the coronavirus and in the interests of health and safety for yourself, all court users, staff, and judicial officers during these extraordinary circumstances. And it looks like you signed it, and it says, I knowingly and voluntarily agree to waive my physical presence in the courtroom and my right to a public proceeding, and I agree to participate in a court proceeding via video teleconference. Is that so?
Yes.
Okay. And I should advise you that it is actually a public proceeding because you're on YouTube. You have a negotiation to present?
Yes, we do, Judge.
Summons of negotiation.
Yes, because the defendant would be pleading guilty to the charge of driving under the influence of alcohol. He'd be paying a fine of $1,000 plus court assessments. He'd be ordered to obtain a alcohol evaluation within 45 days. He'd be placed on 1 year of court supervision, perform 100 hours of community service, and not to be any establishments whose primary purpose is sale of alcohol. There would be a conviction on the improper lane usage charge with a $50 fine, no additional court assessments.
Okay, and I take it he's a first-time offender?
Yes, Judge.
Okay, sir, it's the court's understanding you wish to waive your right to both a jury trial and bench trial and plead guilty to the charge of DUI, Class A misdemeanor, which has a potential penalty of a year in jail and or a $2,500 fine. Is that so?
Yes.
You understand you have the right to both a jury trial and a bench trial, that a jury trial is a trial where 12 people from the community would be picked, the community being Lake County, Illinois. They would hear the evidence and they would make a determination as to whether or not the state's proven its case beyond a reasonable doubt, or a bench trial. That's where a judge would hear the evidence and make that determination. You understand that?
Yes.
Has anybody forced you, threatened you, made you any promises other than what the court has heard here today to get you to waive your right to both a jury trial and bench trial? You had sufficient time to discuss this with your attorney? Yes? You have to answer yes or no. Yes?
Yes.
Okay. And you're satisfied with his representation?
Yes.
And you admit to driving at a time you were under the influence?
Yes.
Court will find that there's a knowing and voluntary waiver of defense right to both a jury trial and a bench trial, and that your admission is a sufficient factual basis to support the plea. This is a final and appealable order, which means you have 30 days to withdraw your plea. If you wish to do so, it has to be done so in writing. If it's granted, basically you start all over again, and the matter will be set for trial. If denied, you'd have 30 days to appeal to the appellate court in Elgin, Illinois. If for either of these two procedures you wish to have an attorney and cannot afford one, one would be appointed to represent you free of charge if you were found to be indigent. Additionally, all records and transcripts of these proceedings would be provided free of charge upon that finding of indigency, and the clerk's office would assist you in filing a notice of appeal. Do you understand that?
Yes, I do.
You are under the jurisdiction of the court while you're on supervision, which means if you fail to comply with the court order conditions of supervision, state could file a petition to revoke the supervision. If they prevailed, you could be resentenced up to the maximum. If you fail to show up when it's set for a hearing, there could be a hearing held without you being present. And if the state prevailed, you could be resentenced without you being present. Do you understand that?
Yes, I do.
And you need to contact the compliance coordinator's office, and you have to contact probation about your public service. Do you understand that?
Yes, I do. Sure. Yes.
Okay. And it appears he's already completed his evaluation, and he's already completed 10 hours of a significant risk program, so he's well on his way to completing his requirements. Anything else from either side?
Judge, I'm not sure if I mentioned, but he was required to complete a victim impact panel, not live, but just a victim impact panel. I think that's in the order. I don't know if I mentioned that or not.
Okay, you understand that, sir?
Yes, I do.
Okay, you're all set. Good luck.
Thanks, Judge.
Thank you.
Thank you, Mr. Patel. Thanks, Mr. Pellizzern.
Judge, I got two more. I don't know if you have anything else scheduled or anything.
Let's take care of you, sir.
I've got Sears, Brian Sears, and Brett Hall.
I'm bringing him in right now.
Okay. Take
There he is. Morning, Mr. Sears. Can you hear me?
Brian, you got to unmute yourself.
Yeah, you're muted right now. I think on your end.
I can hear. Sorry about that. Morning, Judge.
Oh, sir. So what do we have, gentlemen?
Judge, this is 19 DT 1770. We have a negotiation which contemplates a plea of guilty to the charge of driving under the influence of alcohol, $850 fine plus the court assessments, evaluation and treatment, victim impact panel, 100 hours of community service. And my file, Mr. Pinzel, reflects supervised supervision, but I don't have a copy of the order. Was that the agreement or did it get reduced to supervision?
That's correct, Judge.
Well, the court order says supervision.
Okay. There was a stipulation if he completed some of his treatment that it wouldn't be supervised supervision.
And I've got proof that all of it's completed. He's done the 30 hours and he also did a video live victim impact panel. So that's why it's supervision, Judge.
Okay. I take it he's a first-time offender. He's eligible for soup.
Yes,
Yes.
it is. Judge.
Okay, Mr. Sears, before we get started going any further, I've got a document that appears to have been executed by you. It's titled Waiver of Right to be Physically Present During Criminal Proceedings. That states, I, Brian Sears, the defendant in the above entitled cause, acknowledge that I've been advised and understand that I have a constitutional right to be present at all proceedings regarding my case. Further, that I have a constitutional right to confront my accusers. Finally, I have been advised that I have the right to a public proceeding. I acknowledge and understand that a state of emergency has been declared by the governor of the state of Illinois in order to prevent the spread of the coronavirus. And in the interest of the health and safety of myself, all court users, staff, and judicial officers during these extraordinary circumstances, it further states, I hereby knowingly and voluntarily agree to waive my physical presence in the courtroom and my right to a public proceeding, and I agree to participate in court proceedings via video teleconference. You agree to all that?
Yes, Judge.
And you executed the document? And you
Yes.
you signed
Yes.
it? I should advise you that notwithstanding what it says, it actually is a public proceeding in that we're live on YouTube. So somebody in Beijing could be watching.
They want.
Sum and substance of the negotiation.
Judge, the defendant would be placed on 1 year of supervision, $850 fine plus court assessments, a level 2 significant risk program, victim impact panel, and 100 hours of community service. And the failure to obey sign would be a $25 fine conviction, no additional court assessments.
That's your understanding, Mr. Pincel?
Yes, Judge.
And that's your understanding of the plea, Mr. Sears?
Yes, sir.
Mr. Sears, you understand you have the right to both a jury trial. Number one, you're charged with DUI, a Class A misdemeanor, which has a potential penalty of a year in jail and or a $2,500 fine. Do you understand that?
Yes.
You understand you have the right to both a jury trial and a bench trial, that a jury trial is a trial where 12 people from the community would be picked, the community being Lake County, Illinois. They would hear the evidence and they would make a determination as to whether or not the state's proven its case beyond a reasonable doubt. Do you understand that?
Yes.
or a bench trial. It's where a judge would hear the evidence and make that determination. Do you understand that?
Yes.
Has anybody forced you, threatened you, made you any promises other than what the court has heard here today to get you to waive your right to both the jury trial and bench trial?
No.
You had sufficient time to discuss this with Mr. Pincel?
Yes.
Satisfied with his representation?
Yes.
Feel that this is in your best interest?
Yes.
You're not under the influence of drugs or alcohol today?
No.
You understand that by waiving your right to a trial, you're waiving your right to confront witnesses that may be called to testify against you, call your own witnesses, or even testify on your own behalf.
Yes.
Court will find that there's a knowing and voluntary waiver of the defendant's right to both the jury trial and the bench trial. You admit to driving at a time that you were under the influence?
Yes.
Court will find that your admission is a sufficient factual basis to support the plea. This is a final and appealable order, which means you have 30 days to withdraw your plea. If you wish to do so, it has to be done so in writing. If it's granted, basically you start all over again, the matter to be set for trial. If denied, you'd have 30 days to appeal to the appellate court in Elgin, Illinois. If for either of those two proceedings you wish to have an attorney and cannot afford one, one would be appointed to represent you free of charge, and the clerk's office would assist you in filing a notice of appeal. Do you understand that?
Yes.
You are under the jurisdiction of the court while you're on supervision, which means if you fail to comply with the court order conditions of supervision, the state could file a petition to revoke your supervision. If they prevailed, you could be resentenced up to the maximum. If you fail to show up when it's set for a hearing, there could be a hearing held without you being present. And if the state prevails, you could be resentenced without even being here. You understand that?
Yes, Judge.
When you leave here, or not, usually I would say when you leave here today, if you were here, you need to report directly to the compliance coordinator's office. In this case, you got 24 hours to contact the coordinator's office, and Mr. Pincel can help you with that if you need contact information. Anything else from either side?
No, Judge.
Being the case, I concur with the negotiation. Good luck, Mr. Sears.
Thank you.
Brian, I'll reach out to you later today.
Sounds good.
Thanks, Judge. Judge, my last one's Brad Hall, if we can do it.
Well, I've got, let's see, I've got two that just say iPhone, so I'm not sure who these people are gonna be when I let them in, so we'll see. What's your name, sir?
That's not him.
Okay. What's your name, sir? Can you hear me? Do you have a microphone, sir?
Judge, I think that may be Richard Wilson with Mr. Simonian.
Okay. Sir, I'm gonna put you back in the waiting room temporarily. All right. Okay, so let's see who this is.
No, that's not him either. Let me,
I've got a couple more. Let me see what I can do. See who this person is.
all right, that's Brad in the blue shirt with the beard.
Car appears, or van. Okay. You're Bradley Hall? Can you hear me, Mr. Hall? Do you have a microphone? Right now he's connecting the audio.
Brad, can you hear us? Brad, we need your audio on.
Can you hear us now? Mr. Hall, can you hear us? Can you speak? It appears your microphone's not on, though. We can't hear you.
Brad, say something. All right, we can't hear him.
Can you hear us now, sir? Can you hear us now? We can't hear you. Well,
You want to get some of these other guys out, and
yeah, I'll put him back in the waiting room. Well, I'll leave him in here, and maybe he can.
I'm gonna exit. I got to do something in juvenile, if that's okay, and I'll come back in a bit, if that's all right.
Sounds good.
All right, thank you, Judge.
Yep. So who was that? That was. Put him back in the waiting room. Hello, Mr. Simonian.
Hello, Judge.
What do you got?
Judge, I have something with Mr. Hardman and Mr. Lalazern.
Okay. Let's get Mr.
Judge, I have no objection to taking those matters to Mr. Hartman. That's all he has up this morning, and then we can do it.
Give me a name and a case number.
Yes, Judge. It's 20 DT 155 Debbie Levitt.
I think she's. Do you know if she's in the waiting room? You know if she's here?
Judge, Debbie Levitt is here. My understanding is she is, Judge, she's not physically here.
I got two people up, but neither one of them looked in the waiting room. Neither one of them looked like her, I'm guessing. I have Lisa, so let's see if Lisa's, maybe she's using Lisa's phone.
It's a 767 number if she only has a phone number, but.
Numbers don't come up, they just says iPhone, but they were gentlemen.
Judge, if we want to do the other one, I'll call her right now, if that's okay.
Well, somebody's coming up, let's see if that may be her. Oh, that's AIM.
Okay.
That's AIM. I didn't realize that, or I would put AIM in there sooner. But they can watch us on video, on YouTube. Yeah, it doesn't appear she's in the waiting room, Mr. Simonian.
Okay.
I've got two people that are just marked as iPhone, and I have one of Mr. Pincel's that the mic wasn't working, and the other two appeared to be gentlemen. So, who's your other one that you have with Mr. Hartman?
Judge, I have a Chad Laurel.
20 DT 526.
Did you expect him to be here?
Judge, he said he sent me a note. We'll map soon on Zoom, so I don't know if he's there or not.
Well, you know, I'll pull up the two that I have that are
okay
in the waiting room that don't have names, and you can. Is that him?
No.
How about this gentleman?
No, that's Mr. Wilson. Judge, maybe we could go to Mr. Lalazern's case because I'm 0 for 2 right now.
Okay. Okay. Mr. Lalazern, what do you have left?
Judge, I have one with Mr. Simonian, a plea. It's 20 DT 396. It's Lincolnshire versus Richard Wilson.
Okay, was one of those people Mr. Wilson?
The second one, Judge.
The gentleman with the ceiling fan behind him, I believe.
Yeah, but they're both just listed as iPhone. Let's see if we're lucky and I'll click one on again.
Oh.
No,
The other gentleman, Judge.
There we go.
Good morning.
Hello, Mr. Wilson?
Yes.
Hello, good morning. So we've got you on Zoom, we've got Mr. Simonian, we've got the prosecution. This is up for a plea?
It is,
Yes,
Judge.
Judge.
Okay, Mr. Wilson, before we go much further, I have a document that's been executed apparently by you, which is titled Waiver of Right to be Physically Present During Criminal Proceedings. And it says, I, the defendant in the above entitled cause, acknowledge that I have been advised and understand that I have a constitutional right to be present at all proceedings regarding my case. Further, that I have a constitutional right to confront my accusers. Finally, I have been advised that I have a right to a public proceeding. I acknowledge and understand that a state of emergency has been declared by the governor of the state of Illinois in order to prevent the spread of the novel coronavirus and in the interest of the health and safety of myself, all court users, staff, and judicial officers during these extraordinary circumstances. I hereby knowingly and voluntarily agree to waive my physical presence in the courtroom and my right to a public proceeding, and I agree to participate in court proceedings via video teleconference. Number one, did you execute that? And number two, do you agree to it?
Yes and yes.
Yeah, I should advise you that technically it is, in fact, a public proceeding because we're live on YouTube.
Okay.
So,
right.
So it's kind of like being a rock star. So, sum and substance of the negotiation, please.
Yes, Judge, the defendant would be pleading guilty to the charge of driving under the influence of alcohol. He'd be paying a fine of $2,500 plus a court assessment in order to complete a level 2 moderate risk program, which I believe is already completed, and Mr. Simonian said he would submit that to the court. He would also be ordered to attend a victim impact panel. He'd be placed on a period of 1 year of court supervision, and the remaining charges would be dismissed. Part of our negotiation, which is not going to be entered today, is at the completion of 6 months of statutory summary suspension, there will be a rescission entered. He's got about 2.5 months to go on that, Judge. And we'll just enter an agreed order at that time.
That's correct, Judge.
Okay. Excuse me. Mr. Wilson, it's the court's understanding you wish to waive your right to both the jury trial and bench trial and plead guilty to the charge of DUI, Class A misdemeanor, which has a potential penalty of a year in jail and or a $2,500 fine. Is that so?
Yes, sir, that is correct.
You understand you have the right to both a jury trial and a bench trial, that a jury trial is a trial where 12 people from the community would be picked, community being Lake County, Illinois. They would hear the evidence and they would make a determination as to whether or not the state's proven its case beyond a reasonable doubt. Or a bench trial, that's where a judge would hear the evidence and make that determination as to whether or not the state's proven its case beyond a reasonable doubt. Do you understand that?
Yes, sir, I do understand.
Has anybody forced you or threatened you or made you any promises other than what the court has heard here today to get you to waive your right to both a jury trial and a bench trial?
No, sir, they have not.
You've had sufficient time to discuss this with your attorney?
Yes, I have.
Satisfied with his representation?
Absolutely.
Feel that this is in your best interest?
Yes, sir.
You're not under the influence of drugs or alcohol today?
Oh, absolutely not.
Understand that by waiving your right to a trial, you're waiving your right to confront witnesses that may be called to testify against you, call your own witnesses, or even testify on your own behalf. Do you understand that?
Yes, I do.
Court will find that there's a knowing and voluntary waiver of the defendant's right to both the jury trial and bench trial. Do you admit to driving at a time that you're under the influence?
Yes, sir.
Court will find that your admission is a sufficient factual basis to support the plea. This is a final and appealable order, which means you have 30 days to withdraw your plea. If you wish to do so, it has to be done so in writing. If it's granted, basically start all over again. The matter to be set for trial. If denied, you'd have 30 days to appeal to the appellate court in Elgin, Illinois. If for either of those two procedures you wish to have an attorney and cannot afford one, one would be appointed to represent you free of charge if you're found to be indigent. Additionally, all records and transcripts of these proceedings would be provided free of charge upon that finding of indigency, and the clerk's office would assist you in filing a notice of appeal. Do you understand that?
Yes, sir, I do.
You are under the jurisdiction of the court while you're on supervision, which means if you fail to comply with the court-ordered conditions of supervision, state could file a petition to revoke your supervision. If they prevailed, you could be resentenced up to the maximum. If you failed to show up when set for a hearing, there could be a hearing held without you being present. And if the state prevailed, you could be resentenced up to the maximum without even being here. Do you understand that?
Yes, I do.
And you need to contact the compliance coordinator in the next 24 hours. Mr. Simone can give you that contact information if you don't have it. Any questions, Mr. Wilson?
No questions.
Anything else from either side?
Oh, Judge, I will call Mr. Wilson.
I take it obviously he's eligible for supervision.
Yes, yes,
Yes.
yes.
Okay. That being the case, the court will concur with the negotiation and sentence the defendant as presented here in court today. Good luck, Mr. Wilson.
All right. Thank you very
Thank
much.
you.
What else we got?
Mr.
I've got Mr. Rataka in the waiting room. I'm bringing him in now too.
All right, Judge, Mr. Simone and I have a matter on the 10 o'clock call for hearing. It's Ryan Mumford, 20 DT 403. We're not proceeding today, but we're going to get a date, but we didn't get it, have time to submit an agreed order. So I'll let Simone initiate.
When are you
We're trying to
asking?
resolve this, Judge, but we're not going to be here.
When do you want to do it?
Is that the one, the 25th, I think?
Yeah, that's what we talked about. If that works.
That's fine.
For when?
Next Thursday?
The 26th of June?
We're asking for the 25th.
25th, Judge.
Oh, Thursday.
Yes, Judge.
For plea?
But we're hoping to, Judge. We have to talk to some issues with the state's attorney's office on this, and if we can iron those out, we'll have a plea.
Well, 9 o'clock?
Sure.
Okay. But you don't want a hearing. You just want it for status.
Oh,
on the-
Judge, we'll set it for status or plea, hopefully.
Okay, 25th then at 9 o'clock. Let the state know, please.
We have another one, right, Larry? Davidson, we did the same?
I think we sent an agreed order in on that yesterday.
That's for the 25th.
On, yes, on 20 DT 355. I don't know if the clerk has that.
It looks like it's been continued. It's not on the call today.
Okay.
Thank you.
Yeah, they came in late yesterday afternoon.
Is that it for you, Mr. Simonian, or you still have one that you're looking for?
Judge, I have two. I think Mr. Laurel is in the waiting room. And actually, both mine, I'm advised, are now in the waiting room. We have talked to both of them. Robin has in the last 5 minutes. If that's okay. Mr. Laurel is Mr. Hartman, 20 D 526.
Is that Mr. Laurel?
Yes.
Okay, excuse me. So what are we doing?
Judge,
It looks like it's up for arraignment.
Judge, we're asking to strike July 24th, Judge, if we can arraign him at this time, if that's acceptable.
That's fine. Mr. Laurel, looks like you're charged with driving under the influence of alcohol, operating an uninsured motor vehicle, failure to reduce speed to avoid an accident, and improper lane usage. The most serious is the DUI, which is a Class A misdemeanor, which has a potential penalty of a year in jail and/or a $2,500 fine. Waive formal reading under pleas of not guilty.
Yes, Judge.
Coverage ordered 14 days on the village.
Thank you. Judge, could we strike August 20 or July 24th and have a Friday in August for status?
How about August 14th, 9 o'clock?
Thank you, Judge. Could I ask a question? I wanted to file a petition, but set it for status. Do I do that? Could I have leave of court to do that, or do that at the clerk's office, or?
Yeah, you can do an order that says it gives you permission to do so, and then it'd just be set for status, not for hearing automatically.
Okay, so
And have it set for that same day for status.
that's fine, Judge. So I'll do an order. I'll put by agreement with, or on my motion, and I'll just send that to the 405 clerk.
That's fine.
Okay, thank you.
Okay.
Judge, I have a plea on Levitt. Thank you, Chad.
Okay. Let me see if I got her here.
She's a no.
I'm bringing in someone. Ms. Levitt? It comes up as V50 thin Q, so I don't know if that's,
I think that was Gonzalez guy that was in the car.
oh, is that, oh, that's, yeah, that's right, that's Mr. Gonzalez guy that was in the car.
Yeah.
So I've got Mr. Wexler coming in, and I've got, I don't have your lady in the waiting room.
Okay, I could come back, or we could set a date next week, I guess, if whatever the court requires.
What's your pleasure? I mean, you said she's trying to get in. Do you want to try contacting her again and find out where she
We've
is?
kind of had, sure, Judge, we've had trouble with doing that, but I'll go off and come back in a few minutes if that's okay with everybody.
No, that's fine. Mr. Ritaka, what do you got?
Got me? I had a Dewana Shear judge set for arraignment. I don't know if they.
My clerk doesn't have it. Do you have a case number?
Yes, sir. 20 DT 520.
They moved that to August 21st.
Look, it looks like that got moved to August 21st.
821. Your Honor, I thought I also had a Mark Hall to take his supervised supervision converted to supervision.
Do you have a case number?
I don't have it in front of me, no. Mark
Who's
Hall.
on the other side?
Mr. Lalazern.
Judge, I do know that name. I don't have it on the call for today. I can,
My clerk's looking it up right now.
okay.
It's kind of a common name.
I got it, but nothing was motioned up for today.
He found it, but he doesn't see anything noticing it up for today. Do you want a new date, Mr. Ritaka?
Yes, Judge. Can I have next week?
That's fine.
What
would be-
police department was that?
What's that?
What village was that?
What village is that one?
Round Lake.
Round Lake.
18
Okay.
18 DT 1712.
Thank you.
That'll be June 26th then,
Thank you, Judge.
9 o'clock. Yes, sir.
Have a good weekend, Your Honor.
You too, sir. Take care.
You look good on the video, Your Honor.
Yeah, well, I'm kind of born to be a rock star. I just can't sing or play an instrument.
Are you better than me on the video, Judge? I'm terrible. I'm like Alex Rafferty on the video, Your Honor.
He's probably better than me. So, anyway, have a good one, Mr. Tack. Have a good Father's Day.
Morning, Your Honor.
Hello, Mr. Wexler.
I have a Brad Hall with Mr. Lalazern, who we just, oh, there he is.
That was the V50.
Okay, but we can try him again. He was having trouble with his
Yeah,
mic.
so if we can just put it over for a week.
Hold on, let me get him up here. At least he can, maybe he reads lips. Well, maybe he's not on anymore. Okay, so you want it for 1 week, the 26th?
Yes, please.
26th
Wait,
at 9 o'clock.
Can you hear me? Are you guys talking about me?
Yeah, can you hear us now?
Yeah, I can hear you.
Oh, good. You're Mr. Hall?
Yes, sir.
Good, we can hear you now, so I guess we don't have to kick it for a week.
Awesome. Okay, great.
Okay, Mr.
You wanna do
Wexler's
it?
here now on behalf of Mr. Pincel.
Okay.
Okay.
Well, he's on now.
He's on. Okay,
Sure.
so, Mr. Hall, before we get going any further, I'm just looking for the waiver. Okay, Mr. Hall, I've got a document here that appears to be signed by you. It's called a waiver of right to be physically present during criminal proceedings. It says, I, the defendant in the above entitled cause, acknowledge that I have been advised and understand that I have a constitutional right to be present at all proceedings regarding my case. Further, that I have a constitutional right to confront my accusers. Finally, I've been advised that I have a right to a public proceeding. I acknowledge and I understand that a state of emergency has been declared by the governor of the state of Illinois in order to prevent the spread of the coronavirus and in the interests of health and safety of myself, all court users, staff, judicial officers during these extraordinary circumstances. I hereby acknowledge and voluntarily agree to waive my physical presence in the courtroom and my right to a public proceeding, and I agree to participate in court proceedings via video teleconference. Is that your signature, and did you execute that?
Yes, I did.
I should advise you that it actually is a public proceeding because it's being simulcast live on YouTube. So, anyway, sum and substance of the negotiation.
Judge, we did submit to the court for approval an agreed order to amend the charge from a violation of 11-501 to a violation of 11-503. And if the court would grant that motion, we have a plea to the amended charge.
Priors?
Yes.
Yeah. What?
He has a prior DUI in 2000 out of McLean County, which he was court supervision on.
That's his only prior?
Yes, as far as a disposition out of DUI, correct.
Okay. Please be granted then to amend the charge to reckless driving. Sir, is the court's understand, and then sum and substance of the negotiation?
Yes, Judge, the defendant will be placed on 1 year of misdemeanor probation on the charge of reckless driving. You would pay a fine of $2,500 plus the court costs, $2,000 of which must be paid up front today. He'd be assigned to the DUI unit. He'd be given the all the requirements of the DUI unit, including an open mandate for treatment. He'd have 90 days Lake County Jail, which would be stayed pending a successful compliance with the terms of the probation. He would not be allowed to consume any drugs or alcohol, and would complete an evaluation and complete all recommendations for treatment.
So stipulated?
Yes, Judge.
Okay, Mr. Hall, it's court's understanding you wish to waive your right to both a jury trial and bench trial and plead guilty to the charge of reckless driving, Class A misdemeanor, which has a potential penalty of a year in jail and or a $2,500 fine. Is that so?
Yes.
Yes. You understand you have the right to both a jury trial and a bench trial, that a jury trial is a trial where 12 people from the community would be picked, community being Lake County, Illinois. They would hear the evidence and they'd make a determination as to whether or not the state's proven its case beyond a reasonable doubt. Do you understand that? Or a bench trial is where a judge would hear the evidence and make that determination. Do you understand that?
Yes.
Has anybody forced you, threatened you, made you any promises other than what the court has heard here today to get you to waive your right to both a jury trial and a bench trial?
No.
Had sufficient time to discuss this with your attorney?
I have.
Satisfied with his representation?
I am.
Feel that this is in your best interest?
Yes.
You're not under the influence of drugs or alcohol today?
No, sir.
You understand that by waiving your right to a trial, you're waiving your right to confront witnesses that may be called to testify against you, call your own witnesses, or even testify on your own behalf. Do you understand that?
I do.
Court will find that there's a knowing and voluntary waiver of the defendant's right to both the jury trial and the bench trial, and that your admission is a sufficient factual basis to support the plea. This is a final and appealable order, which means you have 30 days to withdraw your plea. If you wish to do so, it has to be done so in writing. If it's granted, basically start all over again and the matter to be set for trial. with the original charges. If denied, you'd have 30 days to appeal to the appellate court in Elgin, Illinois. If for either of those two procedures you wish to have an attorney and cannot afford one, one would be appointed to represent you free of charge if you're found to be indigent. Additionally, all records and transcripts of these proceedings would be provided free of charge upon the finding of indigency, and the clerk's office would assist you in filing a notice of appeal. Do you understand that?
Yes.
You are under the jurisdiction of the court while you're on probation, which means if you fail to comply with the court order conditions of probation, the state can file a petition to revoke your probation. If they prevailed, you could be resentenced up to the maximum. If you fail to show up when it's set for a hearing, there could be a hearing held without you being present. If the state prevailed, you could be resentenced without even being here. Do you understand that?
Yeah.
Also, you have a state jail sentence. So, in fact, if they filed that petition to revoke right off the bat, actually, even without even filing the petition to revoke, that stay could be lifted if you're not doing everything you're supposed to be doing. You could go into the jail for doing your 90 days. Do you understand that?
Yeah.
Okay. Within the next 24 hours, you have to contact the probation department, and if you don't have the information, Mr. Pincel will get that to you. Any questions by anybody?
No.
Okay, that being the case, the court will concur with the negotiation and sentence you as presented here today. Good luck, sir.
Thank you, Judge.
Thank you.
Thanks for everybody's patience. I appreciate it.
Oh, thank you for yours. Was that all Mr. Pincel had?
That's all I had with him, Judge.
We're waiting for some more and the pro. We have two.
Okay, and we're waiting, Mr. Hartman, what do you have left?
I have
You have, with
plea with
Mr.
Mr.
Simonian, who's
Simonian.
looking for his client.
Right.
Mr. Lalazern, what do you have?
Judge, I think I'm all done for this
Okay, now,
morning. I've got two
I have
pleas
this
at 1:30
gentleman.
with Mr. Weiner.
Okay.
You might be the pro se.
Sir,
Crump.
are you Mr. Crump? Are you Mr. Crump?
Yes, I am.
Okay. Okay, Mr. Crump, it looks like you filed a motion. You're asking to have your fines forgiven.
Yes, sir.
Well, the problem is this looks like it was filed, it's a 13 CF, and it looks like it was a negotiated disposition, and for supervised supervision, and part of that, it looks like part of that is you agreed to pay that, and then 5 years went by and you didn't, so a judgment was entered. And did he ever get his supervision revoked, or the state never filed?
I think it was term satisfied, Judge, back in 2016.
Why would you do that if he hadn't paid?
I don't know. I'm just looking at it just says terminated. It doesn't say either way.
So, well, the bottom line is this: unless the state agreed to it, unless the state agrees to, actually, this has already passed the jurisdictional time, and it's already been sent out to an attorney representing the county to seek collection. So at this point, it's denied, sir. It's 7 years old. The judgment's been entered, and that judgment stands.
Is there nothing that I can do? Because I mean, this has been prohibiting me from receiving many job offers I've been working.
Yeah, you could pay it like you agreed to 7 years ago.
Yeah, but I understand. I've been working minimum wage jobs. I've been trying to pay the cost of living as well. I've been a stand-up citizen. I've stayed out of trouble. Is there there's no possibility to get a reduction or anything at all?
Now, at this point, it's already in collections, it's 7 years old. Like I said, you could have been chipping away at this for the last 7 years and you didn't. So, at this point, your motion's denied, okay? And then, Mr. Sadiewater, if you could do a written order, and then the clerk can send a copy of it to him that just says his motion's denied. So I would call the collection agency and see if you can work out some sort of a payment plan with them. Otherwise, this is just gonna keep on going and going, sir. Or I should say the collection attorney. So he's gone. So give me a written order, Mr. Sadiewater, and then make sure the clerk's office will send him a copy. You're all set, sir.
Well, thanks for your time.
Yep. Is that all you had, Mr. Sadiewater?
Yeah, that's it, Judge. Thank you. And I'll have the order sent over right now.
Mr. Simonian, any luck finding Ms. Levitt?
She's on the phone, Judge. She said she's in the waiting room.
Whose?
Hopefully yours.
I've got me, I've got my clerk, I've got you, I've got Mr. Lalazern, and I've got Mr. Hartman. That's the only people I've got here. I'm not sure whose waiting room she's in.
Okay.
Is she in the 405 waiting room?
She said.
I think it's
yes.
listed under Judge Vorderstasse.
I understand. I'm going to take 5 seconds and call her.
Okay. And Mr. Lalazern, what else did you have?
Judge, I think I'm done. I just wanted to make sure that the clerk didn't have any other files that we haven't called yet.
Not for this morning. You said there's one at 1:30?
Two at 1:30. Two, please, with Mr. Weiner, David Weiner.
Okay.
Good. I'll see you then, Judge.
See you at 1:30, sir.
Thank you.
Yep.
Judge?
Yes.
She's on hold. She says she is in the 405 waiting room. She is having a problem with her signal, but you still don't show it though.
Nope, I've got me, Mr. Hartman, you, and my clerk. Let's see. Let me just double check. That's it. She is in Lake County, right?
She is, I think she's in Lake Geneva, Judge.
I meant in our courthouse, our virtual courtroom.
Okay. She's gonna try again, so.
Okay. Mr. Simonian, Mr. Hartman, it doesn't appear that Ms. Levitt's finding her way through the electronic, highway.
Okay.
You wanna try a do-over?
Can I
at
have
1:30?
5 seconds? I'll call right now, Judge.
Sure.
All right, thank you. Okay, well, the judge isn't gonna wait anymore, so what's,
Oh, no, I'll wait a little bit if she thinks she can get in here.
okay. Okay, are you available? You have to come to my office any day. You're available every day next week? Okay. All right, hold on. Judge, I don't know why she says I can't make it happen. I don't know what that means. So I certainly apologize for wasting Mr. Hartman's and the court's time, but is there an alternative date next week, Judge? I'm sorry.
There's 5 of them,
Oh, okay.
Monday through
Could I-
Friday.
Could I do that?
Whatever works for you and Mr. Hartman, because I'm here every day.
Judge, could I do that Thursday? I'm with Mr. Lalazern if Mr. Hartman's around.
Thursday's fine.
So the
That'd be great.
25th at 9 o'clock for plea.
That'd be great. Thank you. I apologize, Judge.
Okay.
No problem. Thanks, gentlemen.
Okay, thank you.
Have a good one.
You too, Judge.
This is all you can end, right?
Yeah.